Welcome to this special deep dive. It's brought to you by Sinorbit Academy, Sri Lanka.
Hello.
Today, we're really focusing on understanding EU human rights. We're using materials made available to students by the University of London.
That's right. And it's important to say this is purely for educational purposes.
Absolutely. Educational only. And from both of us, the very best of luck for your exams.
Good luck.
So today, fundamental rights within the European Union. That's our target.
Yeah, a big topic.
Our mission really is to give you a clear path through how these rights developed, where they come from, the sources, how they actually get used, applied.
Through the big cases.
Exactly, the landmark cases. And, of course, the Charter of Fundamental Rights, which is so central now.
It really is.
This whole deep dive is designed to give you that structured understanding, hitting the key cases and concepts you'll need.
Okay, let's get right to it then. So initially, you look back at the original treaties, the ones setting up what became the EU.
The EEC and all that.
Exactly. They were almost entirely about economic stuff. Trade, integration,
Right.
and, well, surprisingly little, almost nothing explicit on human rights.
Which seems odd now looking back.
It does. But as the EU, or the community then, started doing more, getting more power beyond just the economy, this lack of clear human rights stuff, it started to feel like a gap, a real problem.
Okay, so the gap was there. How did it start getting filled?
Well, this is where the Court of Justice of the European Union, the CJEU, really steps onto the stage.
Right, the court in Luxembourg.
That's the one. It basically started filling that gap itself. It began recognizing what it called general principles of law.
General principles.
And crucially, these principles included fundamental rights, things we take almost for granted now: human dignity, freedom, democracy, equality.
Proportionality, rule of law,
Yeah.
those core values.
Exactly. Proportionality, rule of law.
Hmm.
The court saw these as sort of the shared bedrock values of the member states, even if they weren't written down in the treaty itself.
So the CJEU was kind of proactive, finding these rights in the system.
Very proactive. And these general principles, they weren't just pulled out of thin air. Later on, they got formal recognition in the treaties. Article 6 of the Treaty on European Union, the TEU, is the big one here.
Article 6 TEU.
Yeah, Article 6.1 is vital. It says the EU respects the rights in the Charter of Fundamental Rights, giving the Charter huge weight. Then 6.2 mentions the goal of joining the ECHR, the European Convention on Human Rights.
We'll come back to that, I'm sure.
Definitely. And Article 6.3, this is key for the early days, says fundamental rights. From the ECHR and from the common constitutional traditions of member states, they are the general principles of EU law. So Article 6 TEU, that's your anchor point for formal recognition.
And there's a mechanism to enforce this too, isn't there? Article 7.
Yes, Article 7 TEU, that's the sanctioning mechanism. It allows action against a member state if it seriously and persistently breaches those Article 6 values.
So even early on, before a big, shiny charter, the foundations were being laid. That development is key to understand.
Absolutely key. And to really see how it happened, you absolutely need to know a couple of the foundational cases from the CJEU.
Okay, lay them on us. Which ones are must-knows?
First up, Case 2969, Stouter v. City of Ulm. This is from 1969.
Stouter, okay.
It involved a scheme for cheap butter, and one version of the rules required people to show a coupon with their name on it.
Right, the butter subsidy case.
That's it. Now, the court didn't actually find a violation of rights in Stouter, but crucially, it stated that fundamental human rights were part of the general principles of EU law, and the court would protect them.
So Stouter is the first big flag in the ground saying we protect these rights even if no breach was found there. Remember Stouter.
Precisely, first marker. Then, just a year later, 1970, you get Case 1170, International Handelsgesellschaft.
International Handelsgesellschaft. Okay.
This one involved a system for serial export licenses where you had to put down a deposit, which you might lose.
Right, challenged based on German constitutional rights.
It's exactly. Economic freedom, proportionality, arguments rooted in the German Constitution. And here, the court confirmed, yes, fundamental rights protection is inspired by national constitutional traditions, but...
There's always a but.
Yes. But these rights have to be viewed within the EU's own structure and objectives. Again, no violation found. But International Handelsgesellschaft cemented the idea that national constitutions were a source of inspiration for these EU general principles.
So Stouter for initial recognition, International Handelsgesellschaft for the link to national constitutions. Both really foundational.
Got it. Foundational. And following these big judgments, the treaties themselves started catching up. Article 6 TEU, as we know it, first popped up in the Maastricht Treaty,
Oh,
and Article 7 TEU came later with the Treaty of Amsterdam. So you see this clear progression, right? From the court leading the way to explicit inclusion in the EU's core texts. Tracking that evolution is important.
definitely. Okay, so we've seen rights emerge as principles get into the treaties. Now, where do these rights actually come from? The sources.
Right. And what's really interesting is how the court itself mapped this out. In Case 473, Nold v. Commission from 1974.
Nold, okay, another key case.
Absolutely. The court in Nold pointed to two main origins for these general principles, including fundamental rights. First, the common national constitutional traditions of the member states.
Okay, national traditions.
Second, international human rights agreements that member states collaborate on or are signatories to.
Right. So, for exam purposes, Nold the case setting out the two primary sources, national constitutional traditions and international agreements.
You've got it. Nold is your source case.
Let's dig into that first one, national constitutional traditions. Sounds straightforward, but was it easy to actually find common traditions across all the different countries?
Well, no, not always. That was definitely a challenge. Two main hurdles, really. First, actually finding genuine common ground. I mean, constitutional systems vary a lot, don't they? What's a right, how it's protected. It can differ significantly.
True. And the second hurdle?
The second was a potential risk to EU law's supremacy. If the court had to constantly bow to potentially conflicting national rules on rights, it could undermine the whole idea of EU law being supreme. It was a tricky balancing act.
Makes sense. How did the court navigate that? Any cases that show this balancing act?
Yes, Case 4479, Hauer v. Land, Rhineland-Pfalz, 1979. That's a good one.
Hauer, the vine planting case.
That's the one. Someone was stopped from planting vines on their land because of an EU regulation managing wine supply. The court looked at the ECHR and specific constitutional rules from some member states.
So looking at both international and national.
Exactly. And it decided that the right to use your property, while important, had to be balanced against the wider EU interest in regulating the market. So Hauer shows the court weighing things up, considering different sources.
Okay. And what about a case showing the difficulty of finding that common tradition?
Case 1579, AM&S Europe Ltd v. Commission, 1982, is often cited here.
AM&S lawyer-client confidentiality.
Precisely. The court was trying to establish that principle at the EU level, and it partly did this by, well, surveying the laws of the member states. It shows the court actively looking for common threads.
Did they find it everywhere?
Not necessarily explicitly in every single state in the exact same way, but enough of a common trend. It highlights the detective work involved sometimes, but then you have a later case, Case 3602, Omega, from 2004.
Oh, Omega.
Yes, Omega. It sort of suggested, look, whether the right comes from a national constitution or is an EU general principle, it doesn't really matter where it comes from. EU law protects it anyway.
Ah, so Omega shifts the focus to the protection itself rather than the precise origin. That's useful. Remember Omega.
Exactly. Protection over pedigree, you might say.
Okay, that covers the national side. What about the second source from Nold International Human Rights Agreements?
Right. Here, the European Convention on Human Rights, the ECHR, is definitely the star player. The CJEU has consistently called it a key source of inspiration. Nold itself said this.
So the ECHR has special status?
It does. But the court isn't strictly limited to it. It has looked at others, too. The European Social Charter came up in Case 14977, Defren v. Sabina, that was about equal pay back in 1978.
Right.
And references have been made to the International Covenant on Civil and Political Rights, even the UN Convention on the Rights of the Child that was in Case C5403, European Parliament v. Council, a family reunification case in 2006.
So ECHR is primary inspiration, but the toolbox is wider.
Precisely. The court draws inspiration broadly when needed.
Okay, so we've got emergence, we've got sources. Now, the really practical bit for exams. How are these rights actually applied?
Yes, the application. This is where the rubber hits the road. We see challenges based on fundamental rights against EU laws themselves and also against national laws when they connect with EU law.
Let's take EU legislation first. Has the court often struck down EU laws for violating fundamental rights?
Often might be too strong a word. There have been many challenges, yes, but outright annulments of EU legislation on fundamental rights grounds are relatively rare.
What about property rights? That seems like a common area.
It is, and there the court often goes back to the principles from Nold and Hauer. Restrictions on property rights are okay if they serve a legitimate public interest and are proportionate.
Proportionality again.
Always proportionality. Case C 8495, Bosphorus v. Minister for Transport, 1996, is a really important example here.
Bosphorus, right, the impounded aircraft due to UN sanctions.
Exactly. An EU regulation implemented UN sanctions,
Yeah.
leading to the plane being seized. The court said, look, the fundamental interests of the international community, in this case enforcing sanctions, justified the restrictions on property and trade rights.
So Bosphorus shows international obligations can justify rights restrictions. That's a key point. Remember Bosphorus.
Definitely. But then you have the Kadi cases, which sort of push back against that idea, or at least refine it.
Ah, yes, the Kadi saga. These are crucial, aren't they?
Absolutely crucial. The first Kadi and Yusuf cases in 2005 involved asset freezes under an EU regulation, implementing a UN Security Council resolution targeting suspected terrorists. Initially, the court upheld the EU measures.
But that wasn't the end of it.
Not at all. The big one
Yeah.
is KC 40205P Kadi v. Council in 2008. This was a landmark. The court fundamentally shifted, it said, very clearly that obligations from an international agreement, even the UN Charter, cannot prejudice the constitutional principles of the EU treaty, including the obligation to respect fundamental rights.
Wow. So EU fundamental rights trump even UN Security Council resolution.
Within the EU legal order, yes. The court annulled the EU regulation because it violated Mr. Kadi's rights of defense and his right to effective judicial protection. He hadn't been given the reasons or evidence against him. Kadi 2008 is absolutely essential. EU rights come first internally. Remember Kadi 2008?
And it came back again, didn't it? The Kadi trilogy, you called it.
Right. He was put back on the UN list. New EU regulation back to court. In 2013, joint cases C5840, C59310, C59510, 2013. This time, the court said the reasons given were detailed enough for him to defend himself. Progress there.
Okay, so fix the procedural problem.
Procedurally, yes. But the measures were still annulled because the court found the reasons given weren't actually backed up by sufficient evidence provided to the court.
So the evidence itself wasn't strong enough.
Exactly. The Kadi trilogy 2005, 2008, 2013 is fascinating. It shows the court grappling with this tension between international security obligations and individual fundamental rights protection within the EU system, understanding that evolution is vital.
Definitely. And fundamental rights arguments aren't just in these big security cases. They pop up in competition law, too.
Oh, yes, frequently. When the Commission investigates companies for breaking competition rules, those companies often challenge the proceedings based on fundamental rights.
Like what kind of rights?
Things like the rights to the defense that was in case C39703P, Archer Daniels Midland v. Commission, 2006. The right to a fair hearing came up in case C1FAM595P, Bostel Goe v. Commission, back in 98. And the principle that laws shouldn't apply retroactively, non-retroactivity, that was in case C189-21302P, Dansk Rohr Industrie v. Commission, 2005.
So it shows these rights permeate even the EU's economic enforcement activities. Good to remember that, Brett.
Absolutely. Fundamental rights aren't confined to a specific human rights box in EU law.
Okay, now let's shift gears slightly to a major current issue. Rule of law backsliding in some member states. How have fundamental rights factored into the EU's response?
This is a huge and very difficult area. The EU's core values are being tested, and yes, the Court of Justice has been central, dealing with challenges to laws in places like Poland and Malta, particularly concerning judicial independence.
Right. What's the gist of those cases?
Well, with Malta, the court ultimately found the judicial appointment process wasn't contrary to EU law because an independent body was involved. But the situation with Poland has been much more confrontational.
Yes, we've heard a lot about Poland. What are the key cases students should know?
The tensions really flared up around 2015 with major judicial reforms. The CJEU has found multiple violations of the rule of law. Key cases to remember: Case C79119, Commission v. Poland 2021, and Case C48719, known as the W case, also 2021. Both found Polish reforms breached EU principles on judicial independence.
And there were financial penalties involved, too.
Yes, very significantly. Case E2421, Commission v. Poland, again 2021, saw Poland hit with a massive daily penalty payment for failing to comply with earlier court orders about its disciplinary regime for judges. These Poland cases are prime examples of the EU using rule of law principles grounded in fundamental rights to challenge member state actions.
It seems like a really tough dynamic, especially using funding as leverage.
It is complex. The EU did eventually approve Poland's COVID recovery plan funds, but conditionally, in June 2022. And concerns remain, not just about Poland, but also Hungary, where the European Parliament has raised serious alarms. The traditional Article 7 TEU procedure, well, it's proven a bit toothless because it needs unanimity among member states.
Which is hard to get if multiple states are potentially implicated.
Exactly. But the EU now has a newer tool, the Conditionality Regulation from 2020, Regulation 2020-2092.
The conditionality regulation, what does that do?
It lets the Commission propose suspending EU budget payments to a member state if breaches of the rule of law principles like judicial independence risk affecting the EU's financial interests.
Ah, a direct link between rule of law and the EU budget.
Precisely. And it has been triggered against Hungary, so it's a potentially powerful new mechanism to watch.
So applying fundamental rights isn't just about checking EU laws, it's a vital tool for ensuring member states adhere to the EU's own core values, especially the rule of law. Really important point for studies.
Absolutely critical. And fundamental rights also come into play when challenging member state laws in other contexts too, not just rule of law. The court has mapped out scenarios where member states are bound by EU fundamental rights.
Okay, when exactly are member states bound? Can you give us clear situations?
Sure. First, when a member state is applying its own national laws, which are designed to implement EU legislation, especially if that EU law itself touches on human rights.
Right, like implementing an EU directive.
Yes, or even applying national rules within the scope of an EU freedom. Case 3675, Rutilli, from way back in 1975, is a classic. National measures restricting free movement of workers had to respect fundamental rights drawn from the ECHR, as reflected in the EU directive.
Rutilli. Okay.
And case 222284 Johnston from 1986 is another big one. It confirmed the right to an effective judicial remedy derived from the ECHR must be guaranteed by member states when enforcing EU rights, like equal treatment. Remember, Rutilli and Johnston for national measures needing to comply when connected to EU law.
Got it. What's the second scenario?
Second, when a member state acts as an agent of the EU, basically implementing or enforcing EU measures, even using their own procedures. In these situations, they have to respect the general principles of EU law, including fundamental rights, just like the EU institutions do.
Even if the EU law itself isn't explicit about that.
Exactly. Case 588, Wachoff, from 1989, illustrates this. It involved compensation under an EU farming scheme, implemented nationally. The court said denying compensation would breach the farmer's fundamental rights, which the member state had to respect when implementing the EU scheme. Wachoff shows this obligation on member states when acting for the EU.
Okay, implementing EU law directly, acting as an agent. What's the third situation?
Third, when a member state tries to derogate from EU law, maybe citing public policy reasons, even then, the court checks that the member state, in doing so, has respected fundamental rights.
So even when they're trying to get out of an EU obligation?
Yes. Cases like Eliniki Radiophonia Teliorasi, ERT, from 1991, and Carpenter from 2002 show this. In Carpenter, the UK couldn't just automatically deport a non-EU spouse without considering the impact on family life rights under Article 8 ECHR because it affected the EU citizen spouse's free movement rights.
Right. And didn't Omega, the German laser drum case, also fit here?
It did, but from the other side. In Omega, Germany successfully justified restricting an EU freedom, providing services, by invoking the need to protect a fundamental right, human dignity, based on its constitution. So fundamental rights act as both a shield for individuals against state action and sometimes as a justification for state action that restricts EU freedoms.
That's a really important duality. So it seems EU fundamental rights have quite a wide reach over member state actions, provided there's some link to EU law. Is there a clear line where they don't apply?
Yes, there is a limit. The court is clear. When member states act in areas completely outside the scope of EU law, purely internal situations with no EU law connection, then EU fundamental rights don't apply. Cases like Cinetech, 1985, and Demirel, 1987 established this.
Okay, purely internal situations are outside.
Generally, yes, but cases like Carpenter and others like Moran or Stephenson show that figuring out exactly where that line is, what is within the scope of EU law, can sometimes be, well, a bit blurry. That's a key point of nuance.
Right. Defining the scope of EU law isn't always simple. Crucial distinction for exams, though.
Absolutely.
This is incredibly helpful on application. Now let's pivot to the Charter of Fundamental Rights itself. You said it's central now. How did it actually come about?
Well, it really grew out of that initial lack of a single, clear list of rights in the treaties. People felt something more concrete was needed. So in 1999, a special body, often called a convention, was set up.
The convention, okay, what was its job?
Its task was basically to catalog all the rights already floating around in EU law from the treaties, from the CJEU's case law, from the ECHR, even from a European Parliament declaration from 1989. The idea was to collect them, codify them, make them visible.
So bringing existing rights together, not inventing new ones.
Largely, yes. Collecting and consolidating. The result was the Charter, organized under those nice headings: dignity, freedoms, equality, solidarity, citizens' rights, justice.
And general provisions at the end.
Exactly. Remember, 1999 is the start of that drafting process.
And when did it become legally binding? That's the critical step, right?
Absolutely critical. It was first proclaimed in Nicene in 2000, but back then it was more symbolic, no direct legal force. The game changer was the Treaty of Lisbon.
Lisbon Treaty, that's the key.
That's the key. When Lisbon came into force, Article 6 TEU was amended to say the Union recognizes the rights in the Charter, and crucially, that the Charter has the same legal value as the treaties.
Wow. Same level as the foundational treaties. That's huge.
It is. It elevated fundamental rights protection massively within the EU legal order. So, for exams, Lisbon Treaty, binding Charter.
Now, I remember something about the UK and Poland getting a special deal, an opt-out from the Charter. What was that about?
Ah, yes, Protocol Num 30. The UK and Poland, and later the Czech Republic, added itself. It was often called an opt-out, but legally, it was maybe less dramatic than it sounds.
How so?
Well, Article 1 of the protocol basically said the Charter didn't create new justiciable rights for those countries or extend the court's powers to strike down their national laws based on the Charter's rights.
But
Their courts were already bound by fundamental rights via the general principles of EU law and national traditions, the ECHR, all interpreted by the CJEU. So the practical legal effect of the protocol was arguably quite limited. It was perhaps more of a political statement, affirming a particular view of sovereignty.
Interesting. More political signal than legal escape hatch.
That's a good way to put it.
So the Charter is binding. Who does it actually bind? What's its scope? Article 51, right?
Exactly. Article 51 is your go-to for scope. It says the Charter applies to the EU institutions, obviously. And crucially, it applies to member states only when they are implementing EU law.
Implementing EU law. That phrase seems key. What does it mean?
It's been hugely debated. Some member states initially tried to argue it meant only when they were directly transposing EU directives into national law, a narrow view.
But the court saw it differently.
Much more broadly. The landmark case here is C61710 Franson from 2013.
Franson. Need to remember that one.
Definitely. Franson said fundamental rights guaranteed by the EU apply in all situations governed by EU law, not just direct implementation. If a national situation falls within the scope of EU law, boom, the Charter applies.
So if EU law is relevant at all, the Charter is relevant.
That's the thrust of Franson. It significantly broadened the potential reach of the Charter to member state actions.
But surely there has to be some kind of connection. It can't apply just because something vaguely relates to the EU.
Right. The court clarified this a bit more in case C2613 Cruciano Siragusa, 2014.
Siragusa.
Okay. Siragusa said there needs to be a certain degree of connection between the national measure and EU law. It has to be more than just an indirect link or the field being vaguely related.
So what counts as a certain degree of connection?
The court listed factors. Is the national law intended to implement EU law? What's the nature and purpose of the national law? Does it pursue EU objectives? Are there specific EU rules covering the matter? Siragusa helps draw the line, needs a more substantial link than just being in the same ballpark.
Okay, that helps refine the Franson principle. Now, how does the Charter interact with other rights sources, like national constitutions or the ECHR? Does it override them?
Good question. Article 53 of the Charter tackles this head-on. It's often called the non-regression clause.
Non-regression.
Yeah, it basically says nothing in the Charter can be interpreted as lowering the protection already offered by EU law itself, by member states' own constitutions, or by international law like the ECHR. The Charter sets a floor, not a ceiling.
So member states can offer higher protection under their own constitutions.
They can, yes. But, and this is a big but, shown in case C39901 Maloney, 2013.
Maloney. European arrest warrant case.
That's the one. Conflict between Spanish constitutional rights and the EU's European arrest warrant rules. The court said, yes, member states can apply higher national standards, but not in a way that compromises the level of protection guaranteed by the Charter itself, or undermines the primacy, unity, and effectiveness of EU law.
Ah, so national standards can't be used to block the application of EU law or lower the Charter's own baseline protection. Mutual trust is key.
Exactly. Maloney is vital for understanding that balance. National protection is fine, as long as it doesn't sabotage the EU system or the Charter's standard.
Okay. What about this idea, horizontal application? Does the charter apply between private individuals, not just between individuals and the state?
This is a really significant and evolving area. Traditionally, things like EU directives mainly had vertical effect against the state. The charter was initially thought to be similar.
But that's changing.
It seems so, particularly for certain core principles. KC 41416, Egenberger, 2018, is key here. The court recognized the horizontal effect of the non-discrimination principle in Article 21 of the Charter, calling it a general principle of EU law applicable between private parties.
Egenberger non-discrimination horizontally. Okay.
Then join cases C56916 and C57016, Bauer, also 2018, seem to confirm horizontal applicability in principle, even for social rights like paid leave, saying Article 51 doesn't prevent it.
So potentially wider than just non-discrimination?
Potentially. And KC 13317, Cresco Investigation 2019, applied non-discrimination horizontally again, striking down an Austrian rule about a religious holiday for similar reasons.
So the takeaway is the charter can have implications in disputes between private individuals or companies, especially regarding fundamental principles like non-discrimination. It's not just state versus individual anymore.
That seems to be the direction of travel, yes.
Yeah.
It's definitely an area to watch.
And finally, on the charter itself, we mentioned it's used in cases about national judicial systems and their independence.
Absolutely. Article 47 of the Charter, the right to an effective remedy and fair trial, has become a cornerstone in the recent rule of law cases, especially those concerning Poland.
So Article 47 is being used to assess whether national courts are independent enough.
Yes, cases like Commission v. Poland, C-12218-2019, and the AK cases, joint cases C-58581, etc., also 2019, rely heavily on Article 47 to assess whether reforms undermine judicial independence, thereby violating the Charter and core EU values. It shows the Charter's power in safeguarding the very foundations of the legal system.
Right. Since Lisbon made the charter binding, the court must be using it a lot more now.
Oh, massively. The increase in references to the Charter and CJEU judgments since Lisbon is really striking. It's moved from being perhaps a background source of inspiration to a primary explicit legal basis in case after case.
It's really come into its own.
Definitely. It's central stage now.
Can we look at some concrete examples? How has the court applied specific charter articles that really help cement understanding?
Sure. Take case C55507, Kucuk-Deveci, 2010. That was about age discrimination in German employment law. The court explicitly relied on Article 21 of the Charter, the non-discrimination clause.
Kucuk-Deveci for age discrimination. Okay.
Then data protection, a huge area for the Charter. Joint cases C9209 and C9309, Volker and Marcus Schecke, 2010. This involved publishing the names of people receiving EU agricultural funds. The court said this violated the right to data protection under Article 8 of the Charter and struck down that part of the EU rules.
Check data protection versus transparency. Got it.
And KC 7010, Scarlett v. SIBAM, also 2010. This was about forcing internet providers to install filtering systems to stop copyright infringement. The court said, nope, that violates the user's right to protection of personal data under the Charter and also freedom of information and freedom to conduct a business.
So Scarlett for data protection and internet filtering, these are great examples.
They show the Charter having real bite.
And you mentioned the Charter influencing how other EU laws are interpreted.
Yes, interpretation is key. Case C57808, Shakrun, 2010. This concerned the EU's Family Reunification Directive. The court interpreted the directive in light of the right to family life, protected by Article 7 of the Charter and the ECHR. This meant overly strict national rules on income requirements for family reunification were potentially unlawful.
So Shakrun shows the Charter acting as an interpretive lens for other EU laws.
Precise.
And Article 47, effective remedy. Any more examples there?
Yes, case C27909, DEB, 2010. This German case involved refusing legal aid to a company because the case wasn't deemed of sufficient public interest. The court said Article 47 applies to legal persons, companies, too, not just individuals, and you can't deny legal aid in a way that undermines effective access to justice. DEB broadened the scope of Article 47.
So access to justice for companies, too. Important point. And the EU institutions themselves, they're bound by the Charter, too.
Absolutely. They wrote it. They're bound by it. Case C56610OP, Italy v. Commission 2013 is a clear example. The Commission published notices for job competitions only in English, French, and German. The court annulled them, finding it breached the non-discrimination principle based on language, Article 21 of the Charter.
So even the EU's own hiring practices have to comply.
Everything the EU institutions do falls under the Charter.
Now, the big data protection cases, Schrems the first and Schrems the second, they were heavily charter-based, right?
Hugely significant, yes.
Yeah.
Schrems 4, C36214, 2015, invalidated the Safe Harbor Agreement, allowing data transfers to the U.S. Why? Because the court, relying heavily on Charter Articles 7, privacy, and 8, data protection, found U.S. law didn't provide adequate protection against state surveillance and lacked effective remedies.
Charter rights used to strike down an international data agreement.
Exactly. And then Schrems II, C31118, 2020, did the same thing to Safe Harbor's successor, the Privacy Shield. Same reasoning, U.S. surveillance laws and lack of redress didn't meet the Charter standards. The Schrems cases are fundamental for understanding data protection law and the Charter's international impact.
Essential cases to know. What about data retention keeping phone and internet records?
Another area where the Charter, specifically privacy and data protection rights, has been crucial. The joint Tele2 Sverige and Tom Watson cases, C-20315 and C-69812, 2016, ruled against national laws imposing general and indiscriminate retention of communications data.
Why? Too much of an intrusion?
Yes, the court said such blanket retention is a serious interference with fundamental rights. Targeted retention for fighting serious crime might be permissible, but only with strict conditions and safeguards, like prior review by an independent authority.
So general surveillance is out. Targeted measures need strong justification and oversight.
That's the gist. And then the headscarf cases. Joint cases C8048C and C34111, IXV WABE, and MH Miller VMJ 2021. These involved balancing the employee's freedom of religion, Article 10 Charter, against the employer's desire for a neutral workplace.
A tricky balance. What did the court say?
It said a workplace policy banning visible signs of political, philosophical, or religious belief can be justified, but only if it's applied consistently to everyone, meets a genuine need of the employer, like projecting neutrality to customers, and is proportionate. It requires careful balancing in each specific context.
So no automatic ban allowed, needs justification and proportionality.
Exactly. It shows the court applying charter rights in very practical, sometimes sensitive workplace situations.
And finally, the Charter clearly covers a wide range of rights beyond the classic civil political ones.
Oh, absolutely. The court has dealt with cases invoking human dignity, case C3410 Brussels on embryonic stem cell patents, freedom to choose an occupation, freedom to conduct a business.
Right to asylum.
Yes. Rights of the child are explicitly mentioned and applied. Even the right to strike, which came up in case C34105 Laval. Also rights to social assistance, housing assistance, access to documents. It's a broad catalog.
So it really covers the spectrum of modern rights. Good to have that breadth in mind for exams.
Definitely.
Okay, let's move to our final big topic. The relationship between the EU and the European Convention on Human Rights, the ECHR. There's separate systems, right?
Yes, absolutely separate. The ECHR is under the Council of Europe, based in Strasbourg. Different organization, different court, the European Court of Human Rights, the ECTHR.
But, as we've already heard, the ECHR heavily influences EU law.
Massively. As we said, the CJEU consistently calls it a primary source of inspiration. Noel confirmed this early on. Cases like Rutilli, Johnston explicitly link EU rights to the ECHR. The CJEU talks about its special significance.
Even though the EU sometimes goes further in its own protection.
Yes, like the AMNS case on legal privilege, where EU law arguably offered stronger protection than the ECHR standard at the time. But the ECHR remains the fundamental benchmark.
And there were those initial tensions, particularly in competition law, between the CJEU in Luxembourg and the ECTHR in Strasbourg.
Yes, a little bit. Early CJEU rulings on Commission Dawn raids, like in Hocht, drew criticism for potentially not fully respecting privacy rights under Article 8 ECHR, as interpreted by Strasbourg. But the CJEU adapted its case law later, in cases like Roquette Frères, bringing it more into line.
So a dialogue, or at least an adjustment over time.
Exactly. Same happened with fair trial rights under Article 6 ECHR in competition cases like Orcam and Hulls. The CJEU generally tries to ensure its interpretation doesn't conflict with Strasbourg's minimum standards.
Now, the EU actually joining the ECHR as a formal party that's been on the cards for ages, hasn't it?
Since the 1970s. And it became a legal obligation under Article 6.2 of the Lisbon Treaty. All the individual EU member states are already parties to the ECHR, but the EU as an institution is not.
What would accession mean in practice?
It would mean the EU itself could be taken to the Strasbourg Court, the ECTHR, for alleged human rights violations caused by EU law or actions. It would add an external layer of judicial scrutiny over the EU.
And that Bosphorus case in Strasbourg, Bosphorus v. Ireland, that's relevant here, isn't it? What was the key idea?
Hugely relevant. That was the Strasbourg court looking at the Irish seizure of the plane under EU rules implementing UN sanctions.
Yeah.
The ECTHR basically said, because EU law provides fundamental rights protection that is equivalent to the ECHR system, we generally won't second-guess actions taken by member states when they're just implementing mandatory EU law without any discretion.
Equivalent protection, that's the crucial phrase from Bosphorus.
It is. It was Strasbourg acknowledging the strength of the EU's internal rights protection, even without formal accession. Remember, equivalent protection.
But despite that, and despite the Lisbon Treaty obligation, the EU still hasn't joined the ECHR. Why not? What's the blockage?
The major roadblock came in 2014 with CJEU Opinion 213.
Opinion 213, okay.
The Court of Justice in Luxembourg was asked to rule on whether the draft agreement for the EU to join the ECHR was compatible with the EU treaties. And the answer was a resounding no.
Why not? What were the problems?
Several big ones. The CJEU felt the draft agreement didn't properly respect the specific characteristics and autonomy of EU law. It worried about preserving its own exclusive jurisdiction under Article 344 TFEU over disputes between member states about EU law.
So, turf wars between the courts.
You could see it that way, partly. The CJEU was also very concerned about the proposed co-respondent mechanism, where both the EU and a member state could be sued together in Strasbourg. It felt this could lead to the Strasbourg court effectively interpreting EU law and deciding who was responsible, EU or member state, which the CJEU saw as infringing on its role in the autonomy of EU law.
So, fundamental objections about preserving the EU's unique legal order?
That was the core of it. The CJEU did outline ways the agreement could potentially be made compatible in future. But for now, accession is stalled because of Opinion 213. That opinion is vital to understand the current situation.
Okay. That brings us pretty much to the end of this incredibly detailed deep dive. We've certainly covered a lot of ground on EU fundamental rights.
We have indeed. So, just to recap the absolute key takeaways for anyone studying this, we saw rights emerge from unwritten general principles recognized by the CJEU.
Cases like Stauder, International Handelsgesellschaft.
Right. Then formalized in the treaties, especially Article 6 TEU. We looked at the sources, national traditions, and international agreements, especially the ECHR, as outlined in NOLD.
Yeah.
The crucial bit, application. How rights are used to challenge EU laws. Remember the Cadi cases and the balance with international law.
Cadi 2008 being key there.
Definitely. And how rights apply to member states when they act within the scope of EU law. Rutilli, Johnston, Washoff, Franson defining that scope. And the rule of law cases, particularly involving Poland.
Then the Charter itself, its creation, its binding status thanks to Lisbon. Article 51 on scope, implementing EU law. Article 53 on the relationship with other sources, the Maloney Principle.
Exactly. And its increasing use by the court across so many areas, non-discrimination, Egenberger, data protection, Schrems IN2, effective remedy, Article 47 in the rule of law cases, and its potential horizontal effect.
And finally, the EU and the ECHR. Separate systems, ECHR as inspiration, the Bosphorus equivalent protection idea, and the big halt caused by Opinion 213 on accession.
You've got it. Hitting those landmark cases and the principles they establish, that's the core task for your exams. Reviewing those key areas is essential.
This has been incredibly helpful, really breaking down a complex area. A huge thank you again to the University of London for making these materials available.
Hear, hear.
And thanks to Sinorbit Academy Sri Lanka for supporting this deep dive. Seriously, good luck everyone with your exam prep.
Yes, all the best.
And maybe just one final thought to leave you with after navigating all this. How do you see this playing out, this constant dynamic, this tension sometimes between national ways of doing things, national sovereignty, and the EU's strong commitment to these fundamental rights? How will that balance evolve, do you think? And what role will the Charter play in shaping whatever comes next?
That's the big question, isn't it? Definitely something to keep watching.
Absolutely. Food for thought. Good luck again.